first half of the paper, there is a lot of language and rhetoric, which is quite colonial and imperial in its character. For example, the white paper describes the UK as becoming a world superpower in artificial intelligence technology. So it's becoming the best in innovation and the hub of where most companies are located, developing this technology and using it worldwide. The white paper also talks about exporting UK values globally, as well as influencing the governance regime in relation to artificial intelligence on the international arena. So when we have a situation where one country is exporting its values worldwide and is essentially leading to a situation where there's standardization and one country is dictating how artificial intelligence is being governed, this is a very straightforward case of colonial domination, because colonialism and imperialism was exactly about one country dominating and influencing the local conditions and the politics, society and people globally. Now, the white paper does have a different kind of discourse in a later section, because there is a section on international cooperation. And here we see a very different type of discourse. And the white paper talks about mutual learning, cooperation, establishing partnerships with like-minded nations to achieve a common goal. And for me, it's very striking that this aspect of mutual learning is only present in a section of international cooperation. So it's very much an instrumental approach, where it's almost like the white paper concedes the importance of diversity and plurality only for the reason that other nations wouldn't, for example, cooperate or wouldn't enter into a conversation if their views were not appropriately taken into account. So for me, this is very much a big contrast, and there is no detailed explanation about how these two conflicting parts can be reconciled. And we know from the work of Anne Orford that we see this troubling trend on the international arena, where countries are cooperating to a less extent in order to solve global challenges. And instead, every country is pursuing its own objective and is trying to become more dominant. And Orford points out that this approach prevents us from solving global challenges, such as climate change, because we are interdependent. And without our cooperation and trust and working together, actually, we are going to be in a very difficult situation where there is climate change and other types of harm. So now that I mention the overall, let's say, this is not the only political or cultural aspect to this white paper, but I think it's important to bear in mind this overarching framework when we then go to discuss the white paper in detail. The approach of the UK in this white paper is that the white paper is very much for the UK context, initially, in the sense that there is no domestic legislation which the government plans to enact unless new evidence emerges which points to the need to do so. And the white paper also explicitly mentions that the government doesn't really want to be part of an international treaty on artificial intelligence, although there is some mention of existing work with the Council of Europe on states acceding to a new treaty. So again, there is some incoherence and contradiction there, but the overall ethos is that the UK doesn't really want to legislate domestically, and it hopes to export this approach globally. So when it comes to regulation, the overall setup of the paper is that the UK as central government will issue guidance to regulators, and then the regulators will have to flesh out the guidance and communicate to the industry in a particular context about how to implement a set of principles which the UK government believes will lead to responsible use of artificial intelligence technology. Now, these principles are varying. For example, they range from having security, for example, cybersecurity or accuracy, to having accountability and remedies. There are also requirements such as fairness and transparency. And what is key is that the regulators will have to apply these principles alongside the requirement to apply these principles in a proportionate manner when deciding what guidance to issue to their particular sector. So, for example, the Human Rights Commission would be telling companies how to design and deploy artificial intelligence applications in a way which avoids discrimination. Now, for my case study, I focus specifically on the interplay between the principle of fairness and the requirement to apply the principle of fairness in a proportional manner. This is my case study because I'm an expert in protecting people from discrimination. And before I unpack my critical reflections on the principle of fairness and the requirement of proportionality, I want to tell you how the white paper defines these key terms, because the definitions are quite important and significant. So first of all, I would like to start with the principle of fairness. Essentially, the government defines this principle in a very narrow manner. The only aspect is that the regulators have to ensure that in issuing guidance, they enable companies to comply with existing legislation. So essentially, the principle of fairness is quite hollow because it doesn't require the regulators to do anything particularly new. So why is this important? Well, we have experts at the Council of Europe who were advising the Council of Europe on the regulation of artificial intelligence technology. And these experts concluded that both domestic laws in the European Union and international instruments, they are inadequate for governing artificial intelligence technology. And that is because artificial intelligence technology brings new aspects, it changes the societal context. And so the existing legal frameworks at both domestic and international levels have crucial legal gaps. Now, the white paper doesn't engage with this aspect, but it does mention that it doesn't address all harms and it doesn't address all the issues. Now, for me, it's perplexing that the paper which purports to set up a global standard doesn't identify all harms or engage with them or create a stronger legally binding framework to deal with these harms. When it comes to principle of proportionality, we have an equally big problem. First of all, the definition is incoherent. That is because the white paper doesn't give one single definition of the principle of proportionality and how the regulators apply it, but it actually has a number of definitions, two of which are, in some cases, very much in conflict with one another. So in one situation, or in one instance, the white paper talks of principle of proportionality in terms of the regulator weighing the risks posed by artificial intelligence technology to society against the benefit of using this technology. The benefit is mostly framed in economic and financial terms, although there is also some reference to increasing overall happiness in society, for example. So the idea here is that if the harm to society outweighs the benefit in terms of economic growth, then the technology should not be used. But in another definition, the government instructs the regulators to apply the principle of proportionality so that technology should be used if the harm to the industry associated with reduced innovation outweighs, so meaning is more important than harm to society. So there are two definitions of proportionality. One says well, if the harm to society outweighs the risks, this technology should be banned. But then another definition in another section of the same paper is saying, well, if the harm to the industry, essentially, and to the industry interests is sufficiently important, then this technology should be deployed. Now, as you can tell from the standpoint of the regulator, when they have two completely different definitions of the principle of proportionality, which contradict each other, it's not even clear to them how they should be acting. This is not the only problem with the principle of proportionality, because we have many historical examples of the problem of using the principle of proportionality. An example is World War II, when American government decided that the principle of proportionality justified the atomic bombing of 2 Japanese cities. So the American government reasoned that the number of lives in terms of how many soldiers who would be saved because there was no ground invasion, that this benefit in terms of military advantage was so high that it justified complete destruction of the 2 cities and everybody who lived there, and also the environment and the long-term environmental damage. So we have enough precedent in terms of the horrific suffering to society, which can be justified by the principle of proportionality, also by reference to societal benefit. And so I think that we need to remember those lessons, not repeat them, and have a very different approach. The next question is, well, what happens when we are actually using the principle of proportionality together with the principle of fairness? Now, here we have a serious difficulty in terms of achieving the goal of protecting fundamental rights, because there's a real risk that the principle of proportionality and its application can undermine the application of the principle of fairness. Let me explain why. So normally, organizations have to comply with legislation. The UK has particular legislation prohibiting discrimination. Normally, under this legislation, if the use of an artificial intelligence application is incompatible with the prohibition of discrimination, then this technology cannot be deployed in the first place. But what we have with the principle of proportionality suddenly is that the application with the legal requirement not to discriminate suddenly has to be weighed against this consideration whether the prohibition of the use of artificial intelligence technology, for example, to select candidates for employment, whether it undermines innovation to such an extent that it's not proportional to prohibit the use of this technology. And so suddenly, the regulator has 2 conflicting considerations to consider. And the white paper envisages a legal requirement on regulators to have due regard to the principles. So suddenly, the principle of proportionality, which is not even legally binding, can undermine compliance with existing legislation because regulators have to be applying both elements. The white paper does acknowledge that principles can come in conflict with one another, and it states that it's up to the regulators to find a trade-off between the 2. Well, I ask you, well, first of all, is it even justifiable to be trading off the protection of people from discrimination against innovation? And are regulators even in a position to be making these type of trade-offs? My last point is that fairness, because it's a narrow definition in terms of compliance with existing legislation, doesn't allow us to be asking bigger questions. For example, we are not asking a question about an equitable global society. We are not asking, for example, questions whether it's even fair that all companies, for example, would be based in one country. We are not asking questions such as whether this kind of legal framework, which essentially strips away existing protections and essentially doesn't even create mechanisms for individuals to litigate, and leaves it to companies to be making important societal decisions by implementing guidance from regulators. We are not asking the question whether we are creating a situation of a race to the bottom, where countries are competing in terms of not addressing societal harms in order to attract companies, promote innovation in the hope of creating this dominant position. We are not asking ourselves the question, well, what kind of world are we going to be living in? That is both detrimental for people in each specific country, but also for our international community. And as we know, we are all interdependent. We know, for example, from the work of Crawford, that artificial intelligence technology actually requires a lot of resources. It's going to be very extractive for the environment. We know about climate change. We know that there are some countries which can go underwater because of climate change. So the way in which the principle of fairness is framed is so narrow that it doesn't really allow us to be asking the kind of questions that we should be asking. Now, just to conclude and to give a balanced approach, I do think the white paper has its own good points as well. And for me, it's the fact that there's regulation of the use of artificial intelligence technology in particular contexts. So rather than just regulating artificial intelligence technology in the abstract, the idea is that there is this tailored approach depending on the application. And that is because there's a real difference, for example, between having artificial intelligence in a toothbrush or a vacuum cleaner and using this type of technology to decide, for example, who gets a job, or how to decide who gets to see a doctor as a matter of priority. So thank you very much for listening to me, and thank you for your questions.